Good afternoon, everyone. Thank you so much for joining our webinar, Infusing Traditional Investigative Techniques into the Audit. Thank you very much today to bring you two of our internal experts on these subjects. Our first is Scott Moritz. Scott is a Managing Director in Protiviti's New York office. He's a global lead of Protiviti's investigations and fraud risk management practice. Scott's got 27 years of experience in leading financial crime and corruption investigations. He is widely regarded as a leading authority on the evaluation, design, and remediation of corporate compliance programs, codes of conduct, and investigation protocols. These guide the work of compliance officers, internal auditors, in-house investigators. He's also spent 10 years as a special agent for the FBI, where he investigated transnational crime, organized crime, money laundering, and corruption. And he's a really good speaker, so I think you'll enjoy listening to him, as well as to our director, Pam Varick. Pam is in our Alexandria, Virginia office. She has over 20 years of risk management experience and expertise in corporate compliance, anti-corruption, and anti-bribery matters. She advises our clients on fraud governance, fraud audits, fraud risk assessment, fraud awareness trainings, and also forensic investigations. So to begin with, and to give us a little introduction to an overview of what we're going to hear today, I will now turn it over to Scott. Thank you for joining us, Scott.
Well, thank you, and good afternoon, everyone. So in today's discussion, we're hoping to give you, some of the tools that may assist you in infusing investigative techniques into the audit. From my perspective as an investigator who works a lot with large companies, we really view internal auditors as that first line of defense in a company's fight against fraud and corruption. And in fact, that is usually you guys are like the Marines and usually are deployed first when there's a need for an internal investigation. And in fact, sometimes in the course of an internal audit that might be more routine in nature, internal auditors are often called upon to pivot because sometimes very quickly a routine audit becomes something other than that when red flags start to surface that may be an indicator of fraud or corruption or misconduct. And some of what we're going to talk about is what to do, how to recognize when it is time to pivot, and some of the steps that you should take to better protect the organization when an audit morphs into an investigation. So in fact, that internal auditors' ability to adapt to the emergence of these red flags is really largely a function of the skills and experience and familiarity that they have with traditional investigative techniques and an understanding of the resources that they can bring to bear on a situation. Internal resources across maybe the various cross-functional partners that you have established within the organization, as well as external resources that may complement or fill any kind of gaps that don't exist internal to your organization. And really the whole purpose of this presentation is to kind of create a little bit of a mindset for internal auditors and provide somewhat of a primer on the investigative techniques and tools that can better prepare you as internal auditors to recognize and respond to fraud or corruption indicators and to begin to assimilate some of these skills into your processes. So with that, and in order to get you the CPE that everyone needs this time of year, I'm going to turn the floor back over to administer a couple of our first two questions.
Okay, great. Thanks, Scott. So the first couple of questions are just testing your knowledge about fraud. What percentage of revenue do organizations lose? Oops, I think I got the wrong question. Stop. Backwards. Here it is. Start audience voting. What percentage of revenue do organizations lose to fraud each year? Here are your options: 13%, 10%, 7%, 5%, and 2%. I'd like to go through the questions quickly so that we can get back to the speaker. So I'll just give you a couple more seconds to let us know what percentage of revenue do you think organizations lose to fraud each year. All right, I think we'll call it there. I'm going to stop the audience voting and go back to the vote list, and I'm going to show you the results. So the majority of you said that, looks like 13 said 10%. So 26% of you said 10% answered B. The correct answer is actually 5%. 5% of revenues organizations lose to fraud each year. So thank you for answering that question. The correct answer was D. You don't have to get the correct answer to be eligible for the CPE credit, by the way. You just have to take the quiz. So the next question that we have, we're going to get two in a row now. How is fraud most likely to be detected? Through tips, through management review, through internal audit, by accident, or by reconciliation? Can you please vote on how you believe fraud is most likely to be detected? I'll give you just a couple minutes to answer this question. 2 more seconds. And let's stop that one and see the results there. So the correct answer is A, tips. And just about everyone got that right. 62% of our audience said fraud is most likely to be detected through tips. So thank you very much for answering those quiz questions. And now, Scott, back over to you.
So thank you. So a couple of important concepts have to do with working under the direction of counsel, which helps establish the attorney-client privilege and also the attorney work product doctrine. In fact, in some instances, if you are involved in an audit that is likely to yield information that may spark the need for an internal investigation, it's sometimes prudent to have that audit supervised by in-house counsel or even outside counsel, depending on what's being examined. And some examples of situations where that may be appropriate is an area where we as a practice work quite often is in evaluating an anti-corruption program or an ethics and compliance program, for example, and looking at things like transactions and other things that could in fact yield information that may spark the need for an internal investigation. Those decisions are often made by in-house counsel or with outside counsel. And then in some instances, a routine audit might be undertaken, and then at some point it becomes apparent that an investigation needs to be undertaken, and that's a good point to confer with your Office of General Counsel and then allow them to make, some decisions as to whether it's now appropriate to bring what you're doing under the auspices of the attorney-client privilege. So just very quickly, those two concepts. So their client and attorney, when someone has engaged in-house or outside counsel to provide them with advice on a legal matter, a privilege attaches that provides some protection to those conversations between an attorney and their client, so that things like legal strategy and other information that is afforded a certain measure of protection. So if something progresses to litigation down the road, some of those conversations between attorney and client don't routinely get turned over in the course of discovery. So that the establishment of that privilege at the outset is very important, just in case. It doesn't have to be when in a situation where litigation is already been filed. It is sometimes it can be established in anticipation of litigation. This might result in litigation. So it's a very important concept. And this covers conversations between an attorney and their client. Adding to that is something called the attorney work product doctrine. So now under this scenario, this protects materials that are prepared in anticipation of litigation from discovery by opposing counsel, and it is people acting at the direction of counsel and the sort of the furtherance of their representation of a client. So in the case of forensic accountants or internal auditors, for example, who are assisting counsel in undertaking an internal investigation, as an example, their work product produced at the direction of counsel also is covered under the attorney-client privilege, but under this this extension of that attorney-client privilege, which is specific to people acting at the direction of counsel. So that's the attorney work product doctrine. These are just important concepts to consider when undertaking an audit that might yield sensitive information, such as when you are auditing for compliance of an area of the law, such as the Foreign Corrupt Practices Act or some other aspect that is has to do with legal compliance of your organization, or in a situation where an audit might yield information to suggest that some improper acts have taken place, and they could lead to some liability on the part of your company. So those are good times to sort of step back, pause a beat, confer with counsel, and then counsel can sort of take it from there and decide whether it is appropriate to establish the privilege and whether the attorney work product doctrine is also applicable. So a couple of other very important investigation concepts that auditors or anyone acting in the furtherance of an internal investigation should be mindful of. And we teach on the subject of investigations and ethics compliance and fraud programs quite often, and often what comes up in the course of conversation when members of the audience are asked, does your organization have a written investigative plan? And large organizations, some of them have dedicated in-house investigators and corporate security professionals, and what we find very surprising is how infrequently, when we ask the question, how many of you have a written investigative plan, seldom do any hands come up, even though they may have dedicated investigative resources. And the problem with not having a written investigative plan is investigations come without warning. The need for an investigation often isn't anticipated, and then time is not your friend. And the unfortunate reality is when the need for an investigation emerges, there's a lot of confusion, or can be, as to who should be overseeing the investigation, whether the privilege should be established at the outset, what internal resources are available that could play a role in the investigation, to the extent that there are gaps in your internal skill sets that would necessitate bringing some outside professionals to assist with things like computer forensics or the performance of background investigations or electronic discovery, things of that nature that don't typically exist inside of an organization. That all of that internal discussion takes time. Identifying those external resources takes time. Negotiating a contract with them takes time. And sometimes the evidence of some sort of misconduct and your ability to keep the fact that an investigation is underway a secret has a shelf life, and sometimes it's a very short shelf life. So for those of you that are sitting there saying, well, we don't have a written investigative policy or plan either, it's something that's worth considering. And it's really, it's a pretty easy process to go through. It takes, you get together in a room, the various stakeholders from internal audit and legal and human resources, and if you have corporate security and IT personnel, get them together in a room and do a little war gaming on the types of things that could come up that would necessitate an investigation, a discussion of the internal resources that are available, any gaps in those resources that might be necessary, and then figuring out how can we compress the timetable to speed our ability to respond, because we've now thought this through. We've developed a list of steps that we should undertake for the various categories of investigation that could be needed, because different events necessitate different investigative steps. A suspected network intrusion is a different set of skills and a different set of protocols than an embezzlement. So kind of wargaming across the various things that could happen, thinking through the skill sets, internal and external, that may be needed, lining up those external resources and having the contracts sort of signed and with the ability to kind of turn them on when needed, all of those sorts of things, and having some written protocols to follow will give your organization the ability to move very quickly, thereby lessening the likelihood that evidence will be destroyed if the person or persons that you need to investigate become aware of your investigation. Some other very important considerations is whether your organization has a written electronic communications policy. And if so, who's responsible for preserving and securing those electronic files, such as emails, electronic documents, and the contents of workstations? Some organizations have a very unpleasant surprise when they seek to recover backup emails and they find out that the email backup wasn't configured properly and that the ability to restore those backup emails or those archived emails doesn't exist because no one checked to see if these backups could be restored. So, and that sort of falls under the category of like discovery readiness and litigation readiness. So, part of it is, what can we retrieve these things when we need them? But the other thing that's very important is, do we have a written electronic communications policy, which often goes to the issue of what your employees, the employees of your company's expectation of privacy should be with regard to business communications, using the email system, using the computer network, and computers and smartphones and tablets that are the property of your company. So making it quite clear that those communications over company-owned assets and networks there is no expectation of privacy, and that's certainly the case in the United States. Outside the United States, where there are some more stringent privacy laws, they may differ quite significantly. So understanding privacy implications associated with an investigation, very important for you as internal auditors to the extent that you're going to get involved in investigations. For organizations that have labor unions as part of their workforce, some collective bargaining agreements have very specific rules associated with that contract or those contracts that sometimes limit the company's ability to perform investigations. So important for you to know as an investigator, as an internal auditor at the outset, are any of these employees that may be the subject of an investigation a party to a collective bargaining agreement because they're members of a labor union, and is there a different standard of care in dealing with these members of the labor union that limits your ability and the types of investigation you could do because of it? Often overlooked and sometimes creates a problem in terms of the evidence that was gathered because it was done in violation of a collective bargaining agreement. Another thing that's just quite important and often overlooked and it can be a trial by fire. Our experience is investigations don't happen during normal business hours. They happen after hours. They happen in the middle of the night. They happen over weekends, often holiday weekends. And that's when your inability to get a hold of people that you need to get a hold of after hours becomes you become painfully aware that you don't have those cell phone numbers that you need in order to put your investigative plan into action. So part of what you need is an internal list of critical contacts that can do things like recover emails off the email system, your email administrator. You can confer with in-house counsel after hours and get their guidance on how to handle an investigation. The various people that you identified in the course of your investigative planning process, you also want to collect their contact information and program it into everyone's smartphone. Who should be on that list? And that should be part of your investigative plan, that telephone chain of getting a hold of those people after hours, so to give you the ability to put that plan into action. Very important and often overlooked. I touched upon this before, but it bears repeating. So most organizations, and quite reasonably, they try to do as much as they can themselves using their own resources, internal audit, human resources, corporate security, information security, IT, but there are limits to your ability for most organizations to identify the universe of cross-functional partners needed in the course of undertaking an internal investigation. And of course, as I mentioned earlier, different categories of investigation require different skill sets and competencies. So depending on the category of investigation, whether it's a network intrusion or an embezzlement, as two somewhat disparate examples, you might need different skill sets. So understanding who the go-to people internally are and having their internal contact information is one important component, but then also understanding that, okay, this category of investigation requires these additional skill sets. We don't have them internally, but we've identified this short list of pre-approved providers that can augment our internal investigative team and very quickly respond to and help us gather evidence in the course of our investigation, and without the necessity and the lost time associated with contract negotiation. Sometimes the negotiation of a contract for us to be retained takes longer than the investigation itself. When you are under time pressure to get to the bottom of something, the last thing you need is to get into some sort of protracted contract negotiation. You want to have those resources lined up and sitting on a shelf for a rainy day. You know, you don't have to pay a retainer or anything else like that. You just have this contract shell in place. You've agreed to the legal framework, and then the only thing that needs to be negotiated, which takes far less time, is what are you going to do over what period of time and how much is that going to cost? That's a much shorter negotiation. So those are just important concepts. Another thing that is important is what role should human resources play when interviewing employees. Different companies have a different view of the role of human resources, but it's important to include them in your investigative planning process. It's important to understand the rules of engagement, and again, that's something that you want to bring out in an investigative plan to the extent that you have one. There are HR implications associated with the collective bargaining agreement that might be in play. Human resources is also very mindful of the various legal limitations around investigations when it comes to your own employees. So it's, just don't lose sight of the fact that HR should have a voice in at least in the planning, if not in participating in your investigation. That the other thing to understand is, law enforcement, when they're doing an investigation, they're gathering evidence with an eye toward bringing a criminal case and gathering evidence to put them in the best possible position to establish that a crime was committed beyond a reasonable doubt. That's not necessarily the objective of an internal investigation. So that investigative plan and that thought process should also consider how much is enough. And that's something that you should periodically step back and decide, have we covered the bases? Have we done all that a reasonable person would expect us to do in light of what we learned? You don't want to spend $1 million to investigate a $50,000 crime. So some economic reality also needs to be factored into the situation. But, sometimes there's this inclination to run down every lead, but there comes a point of diminishing return, and you need to consider that. How much is enough? And when do you involve some sort of outside party, including law enforcement? Another important thing that that internal auditors need to consider when performing an investigation is the documentation is fundamentally different than the documentation when performing an internal audit. Going back to how did that investigation initially start? Was it done under the privilege? If it was, that report should actually be addressed to the attorney that was directing your actions. It should include in the header or footer or prominently displayed on the cover page and on the footer or header of every page, attorney-client privilege, privileged and confidential, attorney work product. So those sorts of things should be on there. So if inadvertently someone comes into possession of that report, they're on notice that this is a privileged communication and that they shouldn't be reading it, because particularly if they're not part of that, that attorney-client relationship. So how to go about documenting that investigation? That's really something that you and counsel should agree on. And one of the things that's very important in investigative report writing is to try to stay away from conjecture, the expressing of opinions. You really want to present a factual deliverable that summarizes and also provides supporting documentation and some more detail on the findings of the investigation without editorializing, an important stylistic consideration. And then the other thing that's important to consider is how should the results of the investigation be communicated internally. These are often very sensitive matters. They are subject to the privilege. One thing I didn't mention earlier, talking about the attorney-client privilege, if you disseminate anything that's subject to the privilege to someone who is not working at the direction of counsel, whose involvement is either they have no involvement or they're not part of the attorney-client privilege that's been established, and you provide them with information or documentation that's subject to the privilege, you have the effect of waiving the privilege. And that's not a great thing because you lose all of those protections. So a very important thing is how do we communicate the investigation internally? Who's permitted to see it and who isn't? Are we making sure that if we're using email or some sort of electronic communication, is it encrypted? And we're very careful in addressing that so we don't misaddress those emails. Some very important considerations. All decisions, by the way, that should be made by counsel who are directing your actions. Just very quickly, there's a lot of moving parts in an investigation. And sometimes internal auditors, their comfort zone is primarily in the books and records of the organization, and that's perfectly understandable. Some of these items here, in terms of data sources, may fall outside of the typical internal auditor's comfort zone, and yet they are very important in terms of potential sources of information for an investigation. So emails and file servers, desktops and laptops, and things like data storage devices, thumb drives and external hard drives, smartphones. We have all sorts of devices, and there's a lot of bring your own device policies in force that there are implications for your electronic communications policy for those. All potential sources of data. There's structured data that exists within databases and journals and other types of records and transactional records. And then there's unstructured data that may likewise be important information, file fragments and personal email that may have been accessed and it may exist within the free and slack space of a computer. Physical paper documents, they still exist, and other electronic documents that are available. Email, voicemail is digitized, telephone logs, access control records into and out of a facility. All of that stuff is potentially digital evidence. Information from surveillance systems, closed circuit television, all of this stuff could have an implication. So just important for you to know what the universe of potential inputs are depending on what you're trying to establish in the course of your investigation. And sort of lastly, this is intended to be a little bit of a high-level framework for what an investigative protocol might look like, sort of the step-by-step process that internal auditors and other people involved in the performance of an internal investigation should follow. So it starts with what is the issue at hand, and reviewing that concern or hotline tip or complaint or something that an audit might have surfaced and that is a red flag. Understanding if it is a whistleblower matter, for example, understanding the whistleblower policy. There's probably a written whistleblower policy that you should familiarize yourself with if you haven't already before forging ahead. A lot of this stuff is the stuff we talked about earlier, and it goes to having that written investigative plan. If you don't have a written investigative plan, then you're going to have to come up with a bit of an ad hoc communication protocol to govern your investigation. Who's in charge? Who are we taking our direction from? Who is within that circle, and that very tight circle of communication, to try to keep the fact that you're doing an investigation secret for as long as you can, because your ability to be effective is largely dependent on secrecy. Secure data in whatever form. This might include things like physically changing the locks on someone's workspace or on an entire premise if it's a large investigation. Make sure that if original file documentation has evidentiary value, don't write on it or staple it or punch holes in it and put it in a binder or alter it anyway. Preserve it. The books and records, are obviously important. Familiar territory for internal auditors, but again, with an eye toward evidence preservation and including information that may be maintained in archives. Sometimes what's often overlooked is the contents of someone's office. I think human nature, people get a little uncomfortable with doing like a search of someone's office, but sometimes it's very important and it can provide a lot of information. These are the types of things you don't want to just do in the middle of the business day because it has a terrible effect on morale and completely destroys your ability to keep secret what you're doing, but it's something that you should at least consider and discuss with counsel, should we search this person's workspace, and how do we gain access to our premises after hours so as not to telegraph what we're doing. Interaction with vendors, vendor confirmations. Some of these things overlap with auditing, but you're doing it for a different purpose, to try to confirm the validity of a vendor that may have actually been used as a means of defrauding the organization. Background checks can be incredibly valuable in providing information as to whether someone you're investigating is living beyond their means, is under extreme amounts of financial pressure, has companies that they've established using their address or in their names that may be vendors to your organization. Those are all very important considerations. And then things we've talked about before, recovering and reviewing deleted email. Conducting interviews is a very important component of investigation. The best to have your ducks in a row before you start doing too many interviews, particularly if the interviewees are potential subjects of the investigation. Also helpful to have people doing those interviews that have some training on how to perform those types of interviews, because you often only get one bite of the apple. So with that, I'm going to turn the floor over to my colleague Pam Varick. Oops, I take that back. We have another tip, and then Pam's going to pick up after this next question for the participants.
That's right. Thank you so much, Scott. I'll ask this quiz question for our CPE attendees, and then we do have some interesting questions that have come in about your section of the presentation. So if you don't mind, Scott, just after this quiz, we'll ask you a couple of those questions, and then we'll get to Pam. For our third quiz question, can you please let us know what you think are the most common source of tips? So the previous question, we found that tips are the most common ways that people discover fraud, but what is the most common source of tips? Go ahead and start the voting on that. The answers are A, anonymous, B, customers, C, employees, D, vendors, or E, competitors. Okay, thank you for answering that question. I'm going to stop the voting now, and we'll show you the results. The correct answer is C, employees. And the majority of you did pick the correct answer, but a lot of people also thought that anonymous is a common source of tips. So thank you so much for those questions. And Scott, before we go on to Pam and her presentation, let me just ask you a couple of these questions that we received from people. Going back to the beginning of your presentation, you'd mentioned about attorney-client protection. And someone wanted to know if you get similar attorney-client protection using in-house counsel as you do with outside counsel.
That's a very good question, and the answer is it depends. So in the United States, you can establish the attorney-client privilege with in-house counsel. The United Kingdom, as an example, you cannot. So it varies country to country, and it's important to understand what country or countries are relevant to your investigation when establishing the privilege. The other somewhat horrifying concept is in some countries the privilege doesn't exist at all, like China, for example. So that's part of that investigative planning process. And a dimension that I didn't mention is considering the variance to your investigative protocol that may be necessary based on the laws in the country in which you're performing those investigations.
Okay, thank you. Another question. Someone says, we obtain from time to time broad allegations, such as your general manager of country X is taking money from business partners, but without more insight, it is hard, if not impossible, to investigate. What advice do you have, considering that we ask for information but receive no response?
Okay, so under that scenario, you've asked some clarifying questions and not getting a response. So yeah, that's part of the triage process of evaluating tips. You're going to get more tips through a hotline, for example, than you'll need to investigate. So part of it is there enough information to act on? If this vague allegation that doesn't seem to have any sort of support doesn't present a logical starting point for you, it's okay not to investigate a very vague and anonymous allegation. There are some things that you could do that are not invasive, that could provide some insight. For example, perform kind of high-level background check on the individual just to see if there are any kind of obvious lifestyle issues that might suggest this person's living beyond their means. But I think it's also okay as long as you document that the decision and the thought process behind not investigating, and they're on a case-by-case basis. It's sometimes okay to do nothing, as long as you considered it and then you document the reasons and the thought and the rationale behind not acting upon a very vague tip.
Thank you, Scott. There are a few more questions, but I think we'll finish we'll do another one of our quiz questions and then turn it over to Pam and see if we have time for additional questions at the end. As I mentioned to the attendees, if you identify yourself in your question, then we will also endeavor to respond to you after the webinar if we don't get a chance to answer your question as we go along. So as we get onto our section about typical frauds and red flags, we'll start with another quiz question. What authority level is most frequently involved in fraud? Is it A, board of directors, B, employees, C, managers, D, owners, executives, or E, other? Which authority level? Okay, we are about up to our usual number of answers, so I will go ahead and stop the voting on this question. And I will show you the results. So the majority of the respondents chose C, that the manager level is the authority level most frequently involved in fraud. However, the correct answer in this question is B, employees. That's the answer about authority level most frequently involved in fraud. So thank you for answering our poll questions. There will be one more before the end of our webinar, but now let me turn it over to our second presenter, Pam Barrick.
Hi, everybody. Thanks for spending some time this afternoon with us. As we approach what I call the trifecta of fraud, so we have, as we end December, we have month-end, quarter-end, and year-end. There are some important red flags that we want you all to be thinking about. Now, a red flag is typically a situation where you may want to apply some extra scrutiny, or people who are approving certain types of transactions or processing transactions should have a heightened sense of what issues are that they need to be on the lookout for. Also want to be thinking about issues where people perhaps have ignored the warning signs or red flags that may cause people to pause before a transaction has been processed. And understanding and making sure that people know when red flags need to be escalated or elevated prior to processing a transaction. Now, understanding that red flags don't necessarily mean that business can't be conducted, but we want to make sure that either red flags, people understand what they are so that there's an additional level of scrutiny or review before the transaction's executed, or as you're considering your samples and your audit procedures, what are the types of things that stick out to you? Patterns, trends, anomalies, perhaps it's organizations to whom payments being made, the amount of the transaction, those sorts of things that would cause you to pause. So those are typically what we consider to be red flags. And we have organized our red flags in terms of typical schemes. So for asset misappropriation, thinking about theft of cash or billing schemes, payroll. This time of year, we often see inflated expense reports or theft of inventory. Things to be on the lookout for, particularly now, is when people are over-reporting any sort of time. So overtime, perhaps time on weekends. You want to be careful about the time that people are putting in. We often see where these types of issues arise, particularly around people who, if you're incented on how many hours you work, people inflating those types of hours. We also see where third-party contractors often inflate their month-end, quarter-end, year-end time in order to make their books look better, and figuring that you all are so caught up in processing transactions you're not going to notice. Theft of inventory. So inventory can be a lot of things. Inventory could mean all of those wonderful things that you have in terms of IT and technical gadgets. So iPads, iPods, Blackberries, cell phones. Look for things that are being extra or over-ordered are oftentimes key points around the holiday season. We also see where office supplies, so if you've got Office Depot or one of those places where you can order a whole bunch of supplies, we often see where they also have a lot of gift cards for sale. So another thing to be on the lookout for are office supplies or office purchases that include gift cards or cash equivalents. Things that, from an inventory perspective, perhaps don't make much sense to you. Why all of a sudden, somebody needed a whole bunch of things from, I don't know, Gap.com were ordered and have been cited as inventory, as we've seen in one investigation, as quote unquote office uniforms. So you got to be on the lookout for those red flags, those things that kind of trip you up as you're going through and say, what is this or why is this? False billing schemes. We see a lot again in terms of people trying to boost their billings and their invoices get padded during this time of year. And then theft of cash, petty cash, particularly, or gift certificates or cash equivalents that you would have on hand. Be thinking about those types of schemes over the holiday season. Financial statement fraud. So again, people trying to make themselves look better for year-end bonuses or perhaps making the year or the quarter look better as we come into financial reporting. So improper disclosures, and not only perhaps in terms of financial reporting, but perhaps in terms of marketing. If you think about fraudulent statements in general, what are people putting in their CVs, or the people you've hired? Do you know whether or not their backgrounds, is the people that you've purported to hire actually have the skill sets? So that when you're marketing to clients or you're saying you have these types of people on board or services that you provide or whatever it is in terms of a statement, you know that those statements are accurate. Fictitious revenues. I'll tell you that the busiest time for forensic practitioners is starting now, as people are starting to accruals are coming into place and you're starting to look at your books from a closed books process. Revenues that perhaps seem out of place or fictitious, or things that are channel stuffing are coming up. So you want to be on the lookout for fictitious revenues. Concealed liabilities and expenses often have a time for bubbling up right about now. And we'll also see improper asset valuation. You want to be on the lookout for things that, again, seem inflated or from a market value perspective seem out of whack. Timing differences are another issue that we see, particularly around month-end, quarter-end, year-end, and understanding whether or not transactions that are being booked, accruals that are being booked, sales that are being booked, is from a timing perspective, is that really making sense to you? Is that accurate? The other thing you want to be on the lookout for, too, are any sort of estimates that really are those real? Are they accurate? Is there any basis for those sorts of things? corruption. What people often say is one of the more benign forms of corruption or conflicts of interest. They're not so benign when you think about how many misdirected corporate opportunities or revenue dollars that has resulted in a loss to your company in terms of overpayment because of conflicts of interest. Kickbacks, particularly around this time of year in terms of, hey, we want to get contracts closed and sold before the new year starts, and hey, if you give us a little something extra, we can make sure that contract gets signed. We can make sure that that deal gets closed. So that often kind of bubbles up at this point in time of year. Illegal gratuities, those sorts of what I'll call improper thank yous. In terms of doing business, in terms of awards of contracts, in terms of getting jobs done way ahead of schedule, perhaps a sort of improper business advantage that's being gained from networking, business trips, conferences that, hey, don't worry about it, we'll pay for your people to go to X as long as you give us Y. We see a lot of those types of improper thank yous this time of year. You really want to be on the lookout for what your corporate policies and procedures are in terms of gifts, meals, and entertainment around the holiday season, and not just around Christmas, but be thinking about what your international holidays are. Chinese New Year will be coming up. You've got to think about Diwali. You've got to think about water festivals. Understand when you're doing your auditing procedures, what are the holidays and festivals in country, and what are you thinking about in terms of gifts, meals, and entertainment around those holidays? And also be thinking about what your corporate policies and procedures are, not just around individual gifts, but in the aggregate to certain individuals or certain entities. Many organizations have certain policies in place where they say, you can't give anything over X to an individual or X to a company in the aggregate. But what we frequently find is that those dollar limits aren't necessarily being monitored or added up. So while you've got it on paper, in practice, that's not really happening. So those are some things you want to be thinking about. Economic extortion, while we don't see this as often, we want to be thinking about those sorts of things where people are trying to extort money out of your organization, perhaps not to shut your website down, perhaps not to release intellectual property that's been improperly obtained, physical safety and security of your people, your plants, your physical office locations. Those are all things that you want to be thinking about. As we wrap up the webinar today, and we want to keep people on time as much as possible. I know you have questions that have come in. Key considerations, the things that we want you to keep in the back of your head from this webinar. Know your red flags. Understand that it's okay to pause a moment and really make sure that the transaction makes sense. Look for patterns, trends, and anomalies. Be aware of those things that are odd or out of context for your organization, for your operation, for your financial processes. Consider really what doesn't make sense or what doesn't belong. And be prepared, as Scott said, that as you're planning these audits, you understand if you have to pivot into an investigation, what you're going to do ahead of time. Make sure you talk to your audit teams about what red flags are and what your expectations are in terms of escalation and review when you see these things. And understand who you need to contact in the organization, particularly as you're coming around to year-end audits, as to what you need to do when you see these things, how you're going to preserve evidence, who you're going to contact, and what role internal audit and other people in the organization are going to play, whether that's HR, whether that's IT, how you interact with legal counsel, as Scott pointed out, very important. Those are all key considerations as we get ready to leave today that we want you to be thinking about. And Ashley, I think we'll turn it over to you so that people who want CPE credit can answer the last question.
Okay, thank you so much, Pam. So the final question is, from first act to detection, what is the median duration of a fraud scheme? Is it 24 months, 18 months, 16 months, or 12 months? If those of you who are seeking CPE credit could just answer that final poll question, please. We'll leave that on, Pam. Well, I did want to at least ask you one question from the audience before we wrap up. We got a question that said, should there be one single individual in the organization as the coordinator of all fraud response activities? Would that foster accountability? And are there any good models and best practices out there as to the structure of that kind of program?
Sure. So when you think about your fraud risk management program, typically there should be somebody at the senior management level who's tasked with responsibility for your fraud risk infrastructure. And when you think about that, we most often see that lodged in with a legal department or with corporate compliance. The fraud risk management program often aligned or akin to the corporate compliance program. Other places we've seen it, we have seen sometimes there is a compliance committee, and the chair of the compliance committee is also responsible for the fraud risk management program. Sometimes it's the chief audit executive, and sometimes we've seen that residing in the CFO's office. I think in terms of investigations, and typically we'll see an investigation policy as well as a fraud control policy. And who owns that, again, varies according to the organization. Sometimes for investigations, we'll see that in legal because they do want to coordinate for privilege purposes. Sometimes we'll see it bifurcated depending on the organization and their size, where internal audit will receive hotline calls, particularly involving financial issues, and so the investigation policy lies with them. And in other organizations, particularly those in the retail industry, we'll see that the corporate security or loss prevention group has investigation protocols or responsibility for fraud risk management programs. So really depends on the industry. I think that there's, I still go back to managing the business risk of fraud, which was way back when in 2008, provides some good ideas on how to structure a fraud risk management program as well as a fraud control policy.
Okay. Thank you, Pam. Something's gone wrong with that final poll question. I apologize. Somehow I can't open it. I don't have the button that says start voting. It looks like the question was closed by mistake, so I apologize for those of you who were trying to answer that last poll question. The correct answer about the median duration of a fraud scheme is 18 months. Answer B. So thank you again very much for joining us on our webinar today. Thank you, Pam and Scott, for your great presentation, and I hope everyone has a wonderful day.